Hello, just like that, we are live. And we are live in a number of locations. And the one location we are not live, and I'm not glancing at my phone to be rude, I'm glancing at my phone because we are live on Facebook, we are live on YouTube, we are live on LinkedIn, and we are live on Instagram. And so when you're looking at me fart around on my phone, that's just me setting up a live video on Instagram, which is where we are now. So hello there. Today we are going to discuss the law of corporate oppression. And if that sounds a little bit weird or a little bit fuzzy or a little bit strange, don't worry, we're going to get through it together. And we're going to find a path forward where we can all sort of understand and learn some stuff together. It's going to be good. Now, what I am going to do is I'm going to do my best to work through sort of three broad sections as we work through this talk. The first is going to be something I might talk about in 2 minutes. I might let everyone fill up the room. Let's do some admin. Firstly, questions, comments, interruptions, engagement, that's all great, and I'm very happy for that, and I'll try to keep an eye on questions over here on Instagram, and I'll try to keep an eye on questions over here on Facebook, LinkedIn, YouTube, and I won't be keeping an eye on any texts that come in, so if you're planning to hit me with some texts, then consider those missed. But that's the plan. Probably let's start in about 60 seconds, 90 seconds. What I'd also like to say is that these sessions are part of a series of CLEs I'm going to be giving over the coming weeks. And the nature of those is going to be corporate oppression this week, derivative actions next week. Then we're going to look at some statutory trustees for sale. We're going to look at, partnership disputes, and then just and equitable winding up. And essentially what I'm going to be trying to do is I'm going to say, g'day, Jackie. Really appreciate you joining the session today. G'day, Bradley. Thank you for joining in. And thanks to everyone for taking some time out of their day. So as I say, this is going to be the first in a series of 5 talks. I'd like everyone to feel very welcome to make comments or to shout out or to do anything else they feel is appropriate through the session. Today is going to be all about corporate oppression. Next week is going to be all about derivative actions. Thank you for the kind comment. I am the Zodiac. That's very generous. Next week's going to be derivative actions. We're then going to have statutory trustees for sale. We sometimes speak about. So I should wave to all these people coming in. Hello there, everybody. I get a chance to click wave, so I'll do that. It's great to see you coming in. Thank you. But today is going to be about corporate oppression. Just a little bit further background. Today's talk, it's sort of a structure that I've arrived at over the years that works in my head, that I hope works in your head too. We are going to start with talking about the substantive law of corporate oppression, the sort of the crunchy nuts and bolts. We are going to talk about, after we've talked about the law, the first bit. Sorry, I'm seeing lovely comments come in. Hader, it's great to hear from you, and thanks for joining the session. Really, really appreciate it. So we're going to talk about the law. Oh, thanks to Penn's. Good to see you guys there. Legend is probably the best coffee shop near you. I hope you'd agree. So the first thing we're going to talk about is the law. Next thing we're going to talk about is some litigated examples in the corporate oppression space. And then the third thing we're going to do, if we have enough time, is make some practical suggestions. And the reason we are not going to spend that long on the practical suggestions is, if I can spoil the ending, my big practical suggestion is going to be get a shareholders agreement in place. If you see me fiddling, I'm someone who fiddles with Lego while I think. So if you can hear little clinkety clanks in the background, that's me. Apologies for that. What other admin and housekeeping have I got to do? I'm giving this from a paper. So if you see me glancing over here, I've got a ridiculously long PDF that I'd be very, very happy to send you. So if you've got to leave early, leave late, or do whatever it might be, I'm going to be uploading this audio to my podcast, Coffee and a Case Note, and I'll have the PDF here ready to share around as well, if that brings you any value. Okie doke, let us get started. Karen, estate litigators, what is up? Great to have you in the room. Some of the issues we're going to traverse today are going to get across that. Yes, very happy to share the paper, but if I can ask you to send the request to me in a DM, because I'm not going to be able to go through all these comments on the live, I'm afraid. So just DM me and I'll send it through to you. That is not a problem. Okay, so let's start at the start. Corporate oppression. We're talking about Section 232 and Section 233. And Section 232 and Section 233 of the Corporations Act deal with two separate issues. Those issues are, I've been asked to disclose the Lego set. This is just my childhood Lego, all in North Sydney Bears colours, red, white, and black, that I have on my desk that I fiddle with while I'm thinking. Sorry to get distracted. Corporate oppression is about Section 232. And what Section 232 says is if there has been commercial unfairness in relation to the management of the company, thank you to all you lovely people who are joining the session, then in that case, the court has a discretion to make orders pursuant to Section 233. And in relation to those two sections, James, everyone is welcome, even if you're not a lawyer. Great to have you in the house. If there's been unfairness pursuant to Section 232, then there can be orders made pursuant to Section 233. And essentially what we're going to be working through today is what does a shareholder who is disappointed in the management of a company do in relation to that disappointment? What orders can they seek and how can they go about things? These are the questions we're going to look at answering today. Why does it matter? We're not going to get into too deeply, because I hope you agree that when you are acting for a disappointed shareholder client, or when you yourself might be a disappointed shareholder in your own personal capacity, then the idea of being locked into an arrangement you don't want to be in, or the idea of having sort of income or assets not available for you to put to use as you might see fit, is enough of a motivation to understand why this stuff's important. But we'll get into it in finer detail as we progress. One final bit of housekeeping that I should have mentioned, and I might have, is comments, questions. That's fine. There's no need to hold back on those. Feel free to ask or yell or text me. If you've got my number, I actually see it coming down at the top. So I've received a couple of those. So thanks for those too. All right. Oppression is sometimes referred to as the most effective minority shareholder remedy. And in the coming weeks, we're going to deal with various different kinds of shareholder remedies, but we're talking about corporate oppression, sometimes called the most effective shareholder remedy. And I'm inclined to agree respectfully with that suggestion, and I'm going to unpack sort of what that's going to mean for us today. But in essence, what I'd like us to take from that idea that it's a most effective minority shareholder remedy is a couple of things. Firstly, when we're dealing with minority shareholders, they are often the shareholders who are going to be forced out of an arrangement. They're the shareholders who are most likely going to come to you feeling aggrieved. They're the shareholders who are most likely going to come to you and say, the way this company is being run is commercially unfair. We're going to get to what these words mean as we progress. Now, what I also want to highlight in relation to saying the most effective minority shareholder remedy is that corporate oppression is not merely for minorities. It's not merely for our 1%, 10%, 15% up against the big bad 2/3 or up against the big bad 75% or whatever it might be. A person, a shareholder, can make an application pursuant to Section 232 of the Corporations Act if they own a 1% share, a 10% share, a 49% share, 50%, 51%, 100% share. Sorry, I'm doing all the waves. It's lovely to have you all joining the session. I appreciate that. Now, it's always great to hear from LinkedIn user as well. I'm just getting that as LinkedIn user on my screen. Some of these have a description. Some of them are just users of various platforms. It's great to have you in the room. Thank you all very much for joining in. Now, as I said, an application may be made not merely by a minority shareholder, but by any proportion of shareholder, 1%, 10%, 49%, 50%, 51%, etc. I'm looking at a paper that you can ask for a copy of. By the way, DM me if you want a copy. I'm not going to dive into it too deeply. And I'm particularly not going to read out for you verbatim the sections of the legislation that you're going to be able to just go and find yourself. Great to see you. Ebony, really appreciate you joining the session. Nicholas, great to see you too. So I'm not going to go through and read out the legislation to you. DM me, I'll send you a copy of the paper. You'll be able to see it there. That's the paper I'm glancing at now. But what I'd like to highlight from Section 232 of the Corporations Act that's really important is three things. Firstly, the court may make an order pursuant to Section 233 if the criteria are met. Great to have you join the session, Joe. And there is a discretion that is enlivened, right? So the court, it is not the case that if you are able to prove that the company has engaged in commercially unfair conduct, the court must make an order. It is the case that the court may make an order pursuant to Section 233. Now, that's the first thing. There's a discretion in the court's hands. Secondly, there are no limitations placed on when the sort of oppressive conduct might arise. It could be something that's happened in the past that is oppressive, that is commercially unfair. It could be something that's happening right now that is oppressive, that is commercially unfair. It could be contemplated future conduct that has not even happened yet that could be commercially unfair. It could be relevantly oppressive, if we're using the loose language of corporate oppression like that. So there's a broad range of potential conduct that could attach to Section 233 orders that we're going to get to. But what I'd like you to understand is that if there's commercial unfairness, the court has a broad discretion about what to do. In finding there has been commercial unfairness, the court can find that about something past, present, future, or all of it. And I want to repeat the point I made earlier, that this can relate to conduct that is unfair to one shareholder, one tiny little baby shareholder, 5% of the shareholders, 10%, 49%, 50%, 51%, 75%, 100%. Any proportion of shareholding entitles you to relief. And so that is the position I want you to have in mind. Section 232 of the Corporations Act. If there's commercial unfairness, the court may make Section 233 orders, and I'm going to tell you all about Section 233 in a sec. So if there's commercial unfairness, the court may make Section 233 orders. The commercial unfairness could be past, present, future, and the people who can apply for orders can be 1%, 10%, 50%, 100% shareholders. That's Section 232. We can get into it. Now, we've got a great question from Tamara. No time limitations on past conduct. That's a good question. No, I think is the short answer, although we'd have to look at how the Limitations Act applied. But the real thrust of corporate oppression, and we're going to get to this, is a really good question. The real thrust of corporate oppression is, remember I said the court has a discretion as to whether to make orders. Now, the court will exercise that discretion if it comes to the view that those orders can cure some existing oppression. So let's say something happened 100 years ago that is currently causing there to be commercial unfairness. Well, arguably, that is something that Section 233 orders could attach to. And let's say there's something that happened last week that was commercially unfair, but it is not currently causing the symptoms of commercial unfairness to be visited upon the shareholders. Well, in that case, the court may not be moved to make any orders at all. So the orders are crafted to cure an oppression that exists. It's about relieving this oppression. It's not about a scorecard or weighing scales or anything like that. The court has a discretion, and it's about relieving that. Tamara, I hope that's a useful preliminary answer, and hopefully when we get into the examples, that'll make more sense. Imogen, oh, nice. Well, Imogen, always nice to have nice compliments that you can then click up onto the screen. So I'm grateful for those. And thank you to you all for all your comments. I'm trying to read as many as I can, and it's just nice to see them come in. So Section 233 of the Corporations Act is essentially just a list of orders that the court can make. So remember what we were speaking about before with Section 232, where we're able to say Section 232 of the Act says if there's commercial unfairness, the court may make a Section 233 order about past, present, future conduct for one, some, or all shareholders. Remember that? So what is a Section 233 order? Well, I'm glad you asked. A Section 233 order is all about almost everything. right? There is a final category that the court can require a person to do a specified act. So there's a big list. The court can say the company can be wound up. You can amend the constitution. You can grant permission for some people to conduct or defend pieces of litigation. You can authorize a member to do something on behalf of the company. You can appoint a receiver. You can appoint a receiver manager. You can appoint a provisional liquidator. A liquidator, in the case of a final winding up, you can appoint. You can regulate the company's affairs in future, or as I said, you can require a person to do a specified act. And I want to linger on that last criterion, because requiring a person to do a specified act is a very, very broad head of relief indeed. Joe, thank you. You're very welcome. So what I'd like us to have in mind is that Section 233 orders can be almost anything, but they are almost always either a share sale at fair value or a winding up order. And we're going to come into the distinction between those two as we work through this. So can I please have clear in our heads what Section 232 is about and what Section 233 is about? Section 232 is all about the court being able to make 233 orders, right? So Section 232 says if there's commercial unfairness about a company past, present, future, then the court has a discretion to make orders pursuant to 233. What orders can be made pursuant to 233? Almost anything, but most likely those orders are going to be either a share sale, you've got to buy their shares for X dollars, or it's going to be a winding up, the appointment of a liquidator to wind up to liquidate the company. So Section 233 orders can be anything, but they're almost never anything. They're almost always something, if that makes sense. And that something is almost always a share sale for fair value. Now, in this paper, I've got a number of little sets of criteria that can help us narrow down into precisely how oppression works. So I will repeat that invitation. JB, great to see you. I will repeat that invitation to you to say, look, if you'd like a copy of the paper, just ping me a DM and an address I can send it to, and then I can pass it on to you. And so I'm not going to go through all these criteria here, but there are some useful ones just as we ground our thinking. I've got a question here from Jackie Plunkett. Jackie, thank you. Can a shareholder accuse a director of IP theft and wind up to get orders? Yes, is the short answer. So let me just draw this up. And in fairness to Jackie, I should say that you added a comment, Jackie, to say ideally you would have said shareholder. So let's just run this scenario for a moment. So who are we accusing? Can a shareholder? So let's say I own shares in Jackie Pty Limited. I'm just a shareholder. I'm not a director. And Jackie Pty Limited is, let's say, a software company. And what it is off doing is they are off making use of the intellectual property potentially that I have transferred into the hands of the company, let's say. Can I accuse the director of IP theft and wind it up to get orders? Short point is yes, but if we're talking about a director breaching their duties to the company, what is a more likely way of getting the outcome we're after is to pursue the director in the form of a derivative action. Sorry, I'm just getting really good questions coming in here on a number of different platforms. I'll try to get to a number of them. So the director misbehavior question, if I can just point at that in a broad way, great to have you join, Ali. If I can just call the director misbehavior question or the director breach of duty question in a broad way, you can attack two different ways. One way, or you can attack a number of different ways. Two prominent ways are what we're going to talk about this week in this section, and then next week in the next session called derivative actions. You can either bring a Section 232 application to say, I'm being oppressed, this is commercially unfair, or you can, there's another good question, everyone keeps asking good questions, or you can make an application pursuant to Section 236 of the Corporations Act to stand in the shoes of the company to bring a derivative suit on behalf of the company. So Jackie, that's my lawyer's way of saying it depends. And the short answer is yes, it is possible. The longer answer is as part of your advice or in part of considering how you can best assist your shareholder client, you're going to want to sit down to say, right, does it benefit my shareholder client more to bring a derivative suit, which is to stand in the shoes of the company? We'll talk about that next week. Or to seek the sort of relief pursuant to Section 233. Fleur, great to have you join the session. To seek the sort of relief pursuant to Section 233 we've talked about. So often, and again, not to get too sidetracked, but this is a really interesting area, and I'm sorry to have a lot of tabs open, an expression I was taught recently. Sorry to open heaps of tabs, but if I can just follow that open tab, then what I say is the choice of how to pursue a misbehaving director, whether corporate oppression or derivative action, is one that you're going to need to seek a lot of instructions on and give some pretty firm advice on. Because often the broad glib advice I give is if you want to stay, then you bring a derivative action, right? Because a derivative action gets money paid back into the company. But if you want to leave, you go corporate oppression because you either want to sell your shares or wind up the company. So I don't want to be too glib, but my broad answer is to Jackie's question that I'll just bring up for all of our benefit again. Can a shareholder accuse a director of IP theft and wind it up to get orders? Yes, is the short answer. Do you want to give that advice to your client is sort of the secondary point that with great respect to you, Jackie, is not a precise answer to you, but is one I suggest is relevant when thinking about how to advise your client in this area. And that is, well, maybe you can, but do you want to? And that's going to be a matter for instructions. So it's going to be fairly finely calibrated, these things, choosing between oppression and derivative suits. We're going to get to some of those fiddly areas if we have time, but I'm already getting such wonderful questions. We'll see how we go. Nathan asks, what are the elements for demonstrating a shareholder is being oppressed? Ha 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 ha. That is the question, right? So we're sitting here saying, oh, commercial unfairness. Sitting here saying, oh, if someone's been oppressed and these sorts of things. Well, let me get into the test as it's set out. And I don't want to just sit here reading the paper to you all, because as I say, please do feel free just to DM me an email address or whatever. I can send this paper through to you. Unfairness is assessed, and this is one of many versions of the test, but I might give you this version that comes to us. This comes to us via Justice Young, actually, but is set out in a decision that's often followed of Campbell and back office investments. It's a 2008 Court of Appeal decision that is upheld in the High Court. So it's looked upon with great respect regularly as a useful authority. Unfairness is assessed by whether objectively in the eyes of a commercial bystander there has been unfairness, conduct so unfair that reasonable directors who consider the matter would not have thought the decision fair. So unfairness is unfairness in the mind of an ordinary commercial bystander. I say with great respect that that's not the most helpful definition, but I also say that it is supremely broad in order to ensure that there's a very, very broad base for shareholders who face unfairness to be able to recover. So it's deliberately not a closed category of oppressive circumstances in relation to a company. It's deliberately broad, and so that's why my answer is deliberately vague, Nathan. And so I'm sorry for ducking and weaving, but my answer to what is commercial unfairness is, it's commercial unfairness. So I hope that is clear as mud. Breach of fiduciary duty, that is a good point, and that sort of leans into my answers to Jackie's question, to Jacqueline's question earlier, that I hope made sense. So a director owes a number of duties to the company, owed duties pursuant to the Corporations Act, as well as fiduciary duties, and I suspect that was the thrust of your question there. Okay, we are now 25 minutes in, and we've got so much to get through, and I'm still having a great time, which I hope you all are as well. Please keep the excellent questions coming. Now, I'm not planning to go through all of these criteria, but I will linger on a couple. And as I say, I'm reading from a paper that you're welcome to ask me for a copy of, and that is fine. I just want to lean on a 2017 decision of Justice Stevenson that we are going to come to. It's called Munsterman and Raywood, and I'm just getting more good questions that I also want to answer as we progressed. The court's task, g'day Harry, thanks for joining in, is to determine whether on the balance of probabilities this commercial bystander we're talking about would have considered the affairs of the company were conducted unfairly. With great respect, that's not really a closed set of categories, and so it's one that we are going to have to grapple with when we get into the cases. So I'm sort of kicking the can down the road a bit to say, yeah, we'll get to some cases and we'll come to understand it. I'd just like to go through a couple of points in the criteria that His Honour Justice Stevenson sets out in Munsterman and Raywood. And His Honour, with great respect, does a very useful summary of the state of the law in this area as it was in 2017. And with great respect, it's sufficiently authoritative that, in my view, this set of criteria remains extremely useful. So a director can act oppressively, which is to say a director can cause a company to act in a way that is commercially unfair while there is no breach of the director's duties. So you don't need to prove a breach of director's duties or a breach of any other law for conduct to be oppressive, right? So everything I might be doing could be 100% in compliance with the shareholders agreement, 100% in compliance with my duties under the Corporations Act, 100% in compliance with Jonathan Welcome, 100% in compliance with my duties, my fiduciary duties, all those sorts of things as a director. I may be compliant, they might be in compliance with the shareholders agreement that I might have signed in my capacity as a shareholder. I might be compliant with every single law, every single contract, every single thing I've signed. Nonetheless, a commercial bystander might find my conduct to be unfair. Yes, and so conduct of a company's affairs can be oppressive, notwithstanding the fact that it is otherwise lawful. And a final point I want to make regarding timing is what I'm going to get to after I deal with excellent questions from Tamara, who says, could the shareholder claiming unfairness have cost orders against them if unsuccessful? Yes, absolutely. Tamara, our first decision to give away the ending is a shareholder who makes an application, fails, and has a cost order made against them. Cost in the cause, sorry, I'll draw that. Cost to follow the event, largely speaking, in these applications. So it's a real risk. Yes, the short answer to that question. Nathan asks, from what I understand, it might also be helpful to analyse whether they act in their own interest or in the company's and whether they specifically act in prejudice the interest of their shareholder. Yes, we're sort of drawing a line there quite finely between whether we're talking about a director breaching their duties, because remember, we don't need a breach of duties in order to succeed in our corporate oppression application. So what you've raised is relevant but not absolutely decisive. I hope that makes sense when I raise it there. So if you were able to prove that a director was behaving in a way that was improper and bad and all that sort of stuff, yes, that's very useful, but it is not absolutely in and of itself decisive, because a director can still be complying with their duties. They can still be acting in the best interest of the company and not preferring their own interests to the company's interests, and still causing the company to behave in a way that is commercially unfair. Hope that makes sense. So it's useful, but not determinative, and not indeed absolutely necessary. Hope that makes sense. Okay, gosh, we're nearly halfway through. We haven't got to any cases. I'm so sorry. And if I can just linger on a final point. Oh, no, sorry, timing. I said it gets timing as well. Ooh-wee, this is going to be a long presentation, or we might have to have some follow-up questions or something like that. I'm really enjoying spending time with you all. I hope you're having a good time as well. Now, timing. The question of, is the conduct unfair, is answered at the time at the time the application is made. You're welcome, Tamara. If the conduct, I'll draw that. If the oppression, if the symptom of the conduct continues, then it is at the final hearing that the orders are crafted. Let me just walk through that slowly for you. So the question of, is it commercially unfair? Let's say I file my claim today and we have our final hearing in 2 years. The question is it unfair? The answer to that is it unfair at the time, 20 July 2023, when I filed my application. The question of what 233 orders should the court make, is answered at the time of the final hearing in 2025. Now, that might sound a little wonky when I raise it now, but I just want to be explicit, because the relief in corporate oppression proceedings is crafted to relieve the oppressive circumstances, symptoms. And if there's no oppressive circumstances, well, there's no problem for the conduct, for the orders to attach to. Rob, great to have you join the session. Does that make sense? So I can prove that I was being oppressed today, but if everything's all fine in 2 years' time, then I lose in my application, right? Because I might have been able to prove the conduct was commercially unfair, but I was unable to move the court to grant me relief. And that's where I want to leave a review of the law. I want to do a quick bit of housekeeping, and then I want to move on to some cases. Housekeeping is today's talk is in 3 parts, as all these talks are going to be, I think. Part 1, the law. We just did that. We went in deep. Part 2 is coming up. Part 2 is we are going to talk about some litigated examples of where corporate oppression rubber hits the road. Section 3, going to be a couple of practical suggestions, and those suggestions are basically going to be get a shareholders agreement, make sure it's got some good terms in it. Other admin, I'm reading from a paper. If you want a copy of the paper, DM me. I'll send it to you. That's fine. And that's about it. Let's get to some litigated examples. I'm getting a number of questions on a number of different platforms about timing, and I like them, but I think I can answer them by giving you a summary of this upcoming case. So please don't think I'm ignoring these very good questions coming in about timing. I want to go to the case of Shanahan and Jatese, the decision of Justice Hammerschlag, as his honour then was, in 2018. It was later upheld in all relevant ways on appeal. And so we might dive into it because I think it helps with this timing point. So we got a company. As almost all these stories commence, we do have a company, and that company is operating an eye hospital in Canberra. And that company's eye hospital is owned by a number of shareholders, and each of those shareholders is an eye surgeon. And the way each of those eye surgeon shareholders get money out of the arrangement is they cause the company to engage them to perform these eye surgeries. Money gets paid to the company for the eye surgeries, and then the owners, the surgeons, get money out in the form of payments, dividends from the company. I'm sure they're paid fees and salaries and stuff as well, but that's not the heart of our discussion today. Now, things chug along okay for a number of years until the minority retire. And they head off to the golf course, and they say, I've had enough time, cutting people's eyes open and gluing them back together, or whatever eye surgeons do. Now it's time for me to work on my handicap, and that's it for me, but I'm going to remain a shareholder. And so what our golf course minority do is they play a bit of golf, and I'm sorry to be lighthearted about them doing this. They do whatever they do in retirement, but they continue to draw an income in the form of dividends from the company, right? So they're continuing to earn money, but they're not in there cutting eyes open and stitching them back together. And as you might imagine, the working majority who continue to slave away for the company are not particularly impressed. And so the working majority, they engage in some conduct. And spoiler alert, it's not great conduct, but we're going to come to why in just a sec. The conduct they engage in is they set up a competing company running an eye hospital. They stymie the appointment of a new surgeon who's applied for a job at the eye hospital, where they really sort of get in the way of that appointment going ahead. They appoint a voluntary administrator in circumstances where the company is not insolvent. They do all of these things. And we're not going to go deeply into the details, but the short point is that all of these things are commercially unfair. They are sufficiently oppressive for the court to say, yep, preventing the company from employing this new surgeon, appointing a VA when it's not insolvent, setting up a competing business, all of that is commercially unfair. All of that a commercial bystander would see and say that it meets the test of commercial unfairness. Now, hooray, well done to them. They've won, haven't they? They've satisfied Section 232. Now, what I need to tell you is that in between commencing the proceedings and progressing to final hearing, there was a mediation. And at that mediation, the minority entered into an agreement with the majority, whereby the majority bought the minority's shares. And they bought those shares at a value that was found to be a windfall. It was found to be a value over the market value. They got a generous premium for their shares. So they'd been bought out for a nice juicy price. But all they did at that mediation was sell their shares. They kept marching on with their claim. And so we get to final hearing, and the court says, Section 232, yeah, great. You have met those criteria. You've proved there's commercial unfairness, objective bystander, all that stuff we talk about. And so the court now has a discretion to award Section 233 relief. But do you remember the timing lesson that we all learned together a couple of minutes ago? Well, by the time of the final hearing, the minority are no longer shareholders and they've got a nice juicy price for their shares. And so the court says, well, you're no longer being oppressed. And so there's no symptom, there's no problem for me to attach any orders to. And so you lose in your application, because your application was to move the court toward a certain relief, and we have not. Let's think that through for a sec, because there was a very smart question earlier. All these questions have been great. There's a very smart question earlier that said, look, is a successful shareholder going to get their costs? So let's have a think about what happened. These shareholders fought on, very expensive piece of litigation, I don't doubt. They proved it was commercially unfair, right? And that's what almost the entire fight's about. Was this unfair, that unfair? What are all the facts relating to this surgeon and the BA and the competing company, all this stuff? And they go, yeah, great, we proved that was unfair. Well, what also happened was they didn't get the orders they came for. And so after a dispute about costs, where they said, look, the overwhelming case was about this. The overwhelming case was there unfairness? And we won. We proved there was unfairness. Yeah, we didn't get our relief, but come on, all the costs related to what we won on, we should get our costs. And what the court said was, no, wrong. What you did was apply for orders. You didn't get them, and costs follow the event. And so, notwithstanding having proved they were oppressed, plaintiffs lost. They didn't get the relief they wanted, and they were on the other side of a cost order they did not want to be. So I hope that was a good lesson about costs and that timing issue of the commencement of the proceedings and the relief ordered in oppression proceedings attaching to a specific problem it has to solve. It has to solve a problem, the relief. And if the problem's no longer ongoing at the time of the final hearing, then you won't be getting any relief. I hope that makes sense. Oh, these are all such good cases. Let me quickly go through the next one that is called Knight's Quest. Now, this is a 2018 decision of the Supreme Court the Court of Appeal in Victoria, and it deals with an Australian company that manufactures wine in a can. And there's this deal entered into where a Japanese company becomes the 60% shareholder in the Australian company owning this wine in a can. And this Australian company is trying to press into China, right? This apparently a great wine in a can market at around this time, but it's sort of stuttering along. It's facing some problems with licensing and some problems getting into the market generally. One of the problems it's facing is that majority shareholder, that Japanese company I referred to, has a subsidiary, and that subsidiary is also in that marketplace competing with the Australian company and gobbling up some of its would-be market share and not saying anything. It's in there competing in the marketplace, and it's not doing too badly. And so what happens is The 40% shareholders in the Australian company, the minority shareholders in the Australian company, make an application for a share sale. They seek an order pursuant to Section 233 that their shares be sold. Now, the Japanese company is not a director of the company. It's just a shareholder. Just as you are not a shareholder, so you are not a director of BHP, if we take that example, you are a director. Sorry, I'll withdraw that. You are just a shareholder of BHP. You're not sitting there driving the bus. You're just a passenger as a shareholder, right? Well, this application is against the Japanese company. Japanese company don't control the Australian company. And so the court finds that the minority shareholder application fails. And the reason it fails is because the Japanese company doesn't have control of what the conduct was. I'll withdraw that, of what the company does. Does that make sense? So the Japanese company is merely a majority shareholder of the Australian company. It isn't controlling it. And the fact the Japanese company has another subsidiary that's competing with the Australian company is not found to be commercially unfair. And the reason I raise this is not to say, oh, like, isn't life crazy? It's to say applications in this area can take a huge number of different forms. And this is an example where the court found that, yes, you were allowed to say that a majority shareholder's conduct was oppressive. In this specific case and on these specific facts, the orders were not made granting relief, but the application was not found to be improperly brought. It was merely that this case turned on its specific facts. So what's the moral of the story? You can apply for oppression relief against a shareholder and not merely the company itself. I hope that makes sense. Kim, great to see you. Thanks for joining the session. And I do enjoy getting pulled up on my lawyer talk as we work through things. Gosh, I'm skipping through a couple of good cases here. I do want to linger. Look, let's linger quickly on Asia Pacific Joint Mining and Always. This is Queensland Court of Appeal. As I think I've said to you before, all this stuff is in a paper that I'm very happy to send to you. If you DM me and send me your email address, that kind of thing, I'll be able to email it through to you. The real thrust of this case is, I won't go too deeply into the facts, but we've got a fiddly set of companies that do a number of mining kind of joint venture collaborations together. There is an application made by one shareholder for an oppression suit, and that application is successful and a winding up order is made. That's in the Supreme Court. It then goes to the Court of Appeal, and the defendants say, yeah, okay, there was oppression. They accept that. What they appeal is the form of relief. They say, yeah, okay, like there may have been oppression, but what there was not, I'll draw that. There may have been oppression, but the relief ought not be the winding up of a company. That's too drastic. There are other methods the court can use. And remember the method we spoke about earlier, the share sale is the most common alternate method, or indeed the most common method in general. It should be a share sale. It shouldn't be a wind up, is the short point that the appellants make, the unsuccessful defendants and the now appellants are making in the Court of Appeal. And they lean on all this law that, with great respect, does speak in their favour, that says, look, winding up a company is an extreme step. You've got employees, you've got other contractors, you've got all these commercial relationships. We don't want courts wandering around winding companies up without a real serious, solemn reason to do it. Now, while that is relevant, the Court of Appeal comes to what I will call the correct outcome, and I say that with great respect. The court says, no, a share sale would not be appropriate, and we are going on with the wind-up. And the reasons for that are quite specific. The reasons are that valuation is going to be hugely time-consuming, expensive, and a bit clumsy. And one of the reasons for that is that the relevant company has a claim that is asserted to be worth $33 million, the outcome of which is going to be unclear. And so that question of like, yeah, okay, you're telling me you've got a $33 million claim. You don't know if you're going to win or lose, and so you don't really know how much that's worth. Well, let's get a value at a value, that claim that we don't really know what it is. So that's a challenging thing for a valuer to engage with. So that spoke against a share sale and in favour of a wind-up. There were doubts about the appellant/defendant's ability to pay for any buyout order. So we've got this company that's worth tens or hundreds of millions of dollars. You can imagine the court being like, all right, well, you've got to buy their shares out for 30, 40, 50 mil or whatever it might be. Well, there's no real evidence before the court that the defendant has that kind of money. And there are whispers that there are companies standing behind the appellant who could have offered a guarantee, who could have stepped in to say, oh yeah, don't worry about it. We will look after appellant's bill on this one for the purchase of these shares. Well, there's no evidence of that kind on foot. And so the court says, well, there's nothing here suggesting that you'll be able to go through with the purchase if we were to order that. And so the appeal is dismissed. And I'll just linger on that point for a moment, because I think that is, with great respect, a useful one to linger on for a moment, because we have everyone agreeing the conduct has been oppressive. We have everyone agreeing that there's going to have to be some form of relief pursuant to Section 233. We have our primary judge saying, look, it's got to be a wind-up. And then we have our Court of Appeal saying, with great respect, very usefully, because of these reasons, it is going to be a wind-up rather than a share sale. And so if I can use this to go back to the start of our discussion today, do you remember how we spoke about the heart of corporate oppression is Section 232? Was there commercial unfairness, or is there going to be, or is there now? So first question, Security, great to see you. Was there commercial unfairness? Is there, or is there going to be? If the answer to any of that is yes, then the court has a discretion to make orders pursuant to Section 233. And remember what we discussed, that Section 233 orders, there are a million. You can order specified people to do specified things. And so what almost always happens is a court's flipping a coin, and I say flip a coin with great respect. That's a very flippant way to put it, if you'll pardon the pun, between a share sale and a wind-up. And what I say that case is of most use in understanding is, right, when is a court going to go with a share sale, and when is a court going to go with the wind-up? Probably only got time for 2 more of these cases, and I'd prepared, oh God, I prepared like 6. Guys, like, do message me and ask for this paper. It's a reasonably good paper. It's like 7,000 words. It's notes I've made before in the past. So some of it, like, it wasn't all fresh for this talk, but it's, it's good stuff. It's good stuff. Let me take you to, look, we're staying in Queensland. I don't know what it is about Queensland. Look, I got love for Queensland for so long as we're winning the 3rd state of origin each year. This is Hunter and Organic. And this is what we might think of, again, with respect, as a bit of a restructure gone wrong. So we've got a company that is trading reasonably successfully in the mid-2000s, around about 2005. And in about 2006-07, it undergoes a restructure. And the nature of that restructure is not particularly unfamiliar to many of us. We've got our trading entity that is trading. We have a new entity that is incorporated. It is the trustee of a unit trust. And then we've got beneficiaries of that unit trust being companies who are themselves family trustees. Right, have that structure in your head, and I'll go through it again if it doesn't make sense first time. Be my poor explanation. You'll understand, I promise. We've got 5 people involved, and I want to split them into 3 groups. And I know 5 divided by 3 doesn't work, but let's say we've got one couple here who are spouses, another couple here who are spouses, and we have another group over here. And in essence, these are our 5 shareholders of our initial trading entity, and they go through this restructure, as I say, and the restructure is the trading entity becomes a person of straw, essentially. We get all the assets, all the risk. You'll have seen structures like this 1,000 times. We get all these assets assigned over here to the unit trustee who holds those assets in trust for the benefit of a number of other entities, each of which are trustees of the family trust. So we've got 3 family trusts, right? Group A, Group B, Group C. And that's the only way to get money out of the trading company these days, because the trading company now has no assets. And so these 5 are shareholders in this company that's now worth very, very little. Sam, great to have you join from Tasmania. What the disappointed person says, sorry, I'll withdraw that. One more element. I need to talk about the way the money flows. So we have our trading entity out there in the marketplace, selling widgets, getting money in. We have our unit trustee here issuing invoices for the trading entity's use of the unit trustee's IP to go, oh, by the way, here's an invoice for exactly the amount of profit you made last quarter. So the unit trustee issues the invoice to the trading company. Trading company pays out the invoice into the hands of the unit trustee. The unit trustee gets the money, distributes it to each of the family trusts. And remember, there's 3 groups of family trusts. That's how they get money out of the structure. Now, one of the spouse groups, they go through family law proceedings. They get divorced or they separate or whatever the start of that process is. I'm not a family lawyer. I don't understand these things. I'm sorry. And that means they are no longer entitled to distributions from the family trust. And that means they can no longer get any money out of this arrangement. And so they find themselves in a situation, I'm getting very playful text messages. That means they find themselves in a situation where they are shareholders in this trading entity. There's money flowing through it. There's money coming over to this unit trustee here, but the only way to get money out is now closed to them due to the family law process they're going through. And so they make an application that this is oppressive. This is commercially unfair. Now, they lose. Why? Let's go into it. Corporate oppression has to attach to conduct. And this is the fundamental reason why this person loses this case. Right? This disappointed spouse is unable to point to any specific conduct that they are able to characterize as oppressive. They're unable to say this moment in time or this contemplated future resolution of the company or this agreement or this improper payment of funds or whatever it might be. They cannot point to it because they were involved in signing off each of these trust deeds and incorporating the new company and all this sort of stuff. They were part of the restructure. They were involved. And so notwithstanding the fact the outcome might be what you and I might think of perhaps as slightly sharp, the outcome is nonetheless not commercially unfair because the spouse is unable to point to any conduct specifically that is commercially unfair. And so the spouse is left having failed in their application, although the court makes the passing comment that might assist anyone who's feeling a little bit bad for the spouse, that family law avenues for recovery still remain open to them. Now, I've got about 1,000 more good cases. I've got to choose one more. I'm trying to choose as quickly as I can. It's tough. So let's choose a decision called Yelland. This is the Victorian Supreme Court a couple of years ago. We're going to get through this one quickly if we can. Quick bit of housekeeping. If I'm going through this too fast or if you joined late or anything like that, all of this stuff, firstly, this whole session will go up on my YouTube channel. I think it automatically goes there at the end. So you'll be able to find it and you can navigate back and forward and that sort of thing. I'm planning to upload the audio to my podcast. I've got a paper here that I can email to you if you want to text me your email address. And this is one of a number of these talks. I'm going to be giving a number of them. There are 4 to go after this one. So if you had fun, tell your friends, come along to the next one. Love to have you. Yelland, Victorian Supreme Court, 2021. We've got it's a little bit complex. We've got a group of architecture firms around Australia. We've got our disappointed person, we're going to call them Y, or our applicant, Y. Y is not our applicant. P is our applicant. That's the company. So Y is the shareholder in this company. P is a shareholder in various architecture firms that are linked as part of a group that go around Australia. Does that make sense? So we've got Architecture Victoria, Architecture Queensland, Architecture New South Wales, and P, which is Y's company, owns shares in Architecture Queensland, Architecture New South Wales, et cetera, et cetera. That is the background position. Now, why, and this is a finding made by the court, there's evidence of why bullying staff and why not being the most productive person for the running of a national architecture firm. There's evidence about why standing in the way of sort of the real business case for how to run an architecture firm like this. And not to peek behind the curtains too much, but if you're trying to run a group of professional services businesses and you want young-ish, sort of senior, junior people to come in, one way of doing that is you drip feed them equity, 1% this year in 18 months or 2%, and you start sort of watering down, with great respect, the established shareholders' equity in order to invite in new people and to attract them into the business and to retain good staff. And one of the problems with why is that why is standing in the way of this. Why should we be giving some of our shares away to these new people, et cetera, et cetera? There's a mediation, and it leads to why purporting to resign, giving 3 months notice, right? About a month later, the directors terminate Y, right? So Y quits, 3 months notice, so that's over here, but Y is terminated a month after quitting with 3 months notice. And the challenge is that if Y is canned, terminated in the way they were, then Y sells, so then P, Y's company, Y's holding company, is forced to sell its shares in the architecture firms at a discount. And so what Y says is, this termination of me after I've quit with my 3 months notice is a confection. It's a what's the word I'm after? It's a deception. It's improper. It's wrong. It is confected merely to cause my company to sell its shares at a discount. It's not a genuine termination. It just happened after I quit, and it's just a way for you to get my shares cheaply. Now, P had to bring that application, right? The company, because Y was not a shareholder. So P is having to say, you fired my owner. You fired my owner, Y. You fired him in order to get my shares for cheap. And there's a big complex valuation dispute that is dealt with at length. And the remaining owners of the architecture firm's evidence is preferred to the evidence of Y and P who are bringing the application. Short point is, because of the operation of the shareholders agreement, because of the correct construction of when termination takes effect, when resignation takes effect in that challenging 3-month notice period, Y fails in its application in relation to P being, P fails in their application to cause the architecture group to accept liability for Y being terminated improperly. That is the last bit of summary I want to do. There's lots of other stuff to summarize in here. I just want to get really quickly to practical suggestions, right? Let's say you're a legal professional, or let's say you are a legal adjacent professional, or you're giving taxation advice or management advice or financial advice, or you're engaged in business with shareholders or with companies and you want to help your clients protect themselves. The really short point is the point we're all familiar with, but hopefully today we've come to understand even better. Vaccine trumps cure. It can always feel like money spent in relation to legal fees, particularly at the commencement of a venture, when you and I might just be seeing if our little widget business is going to get off the ground, spending thousands and thousands of dollars getting complex agreements we're never going to read drafted. Might seem like some money poured down the drain. Well, yes and no. It's an investment in avoiding these sorts of things happen. I've got some suggestions in the paper for the sorts of terms that I say ought to be found in a good shareholders agreement. But the real challenge, if you see circumstances like this arise, is that you can only navigate through them two ways. Way one is agree and record that agreement. Way two is to litigate. And it goes without saying, if you need to litigate, that is the way of going about it. That's a very short version of what is very, very long in the paper. That is a very short version of what I came to talk to you about. Quick bit of admin. If you want the paper, message me. I'll send it to you. Please tell your friends and join us at the next one. It's going to be 12:30, 27 July. We're going to deal with derivative actions. It's sort of a sibling to corporate oppression. So if you've still got some questions and sort of lingering thoughts about, how does all this work? I'm going to progress our understanding of that next week. Yeah, tell your friends, like, share, comment, subscribe, blah, do all the online stuff that you know is helpful and you know is really, really nice. Really appreciate your time and attention. I might loiter around for another 30 or 40 seconds to see if anyone's got some comments. There's a rumor that I'm going to go with a hip hop outro. No, I'm not. But Haj, appreciate you spreading that rumor, and appreciate the kind compliment as well. So I'll loiter around for another few seconds while you decide which of your mates you're going to tell about the next CLE, whether you really want the paper from me, which I can send through to you, for you to cross out whatever dumb appointment you had in your diary for next Thursday at 12:30 p.m. Eastern Standard Time that you're now going to cancel. And that's about all I had to say for today. So Stonecutter, I look forward to seeing you soon at Town Hall Station. And I thank you all very, very much for your time. Let's see. I'm still live. I haven't clicked end broadcast. Oh, my word. Gosh, you can tell I'm live. I've got those nice thank you. Oh, all right, I've got those nice thank yous. Hey, hope you feel better for the next one, Jake. Thank you. Joe, thank you. Adam, thank you. Great to have you all. Adam, beard looks great on you. Love it. I'll get out of the way. Thanks, team.